Namaste, I hope that you're doing well. So this is part 1 of the lecture on interim orders. Aaj we will be covering out the preliminary introductory portion of this topic. However, the main crux, that is in order 39, will be covered in the next lecture. I would like to focus on arrest and attachment before judgment in this lecture. So let's start. So interim for the time being. So interim का मतलब क्या है? अब एक्चुअली जो होता है कि भाई ट्रायल तो लंबा चलेगा, यू फाइल्ड अ सिविल सूट, प्लेंटिव आया, डिफेंडेंट आया, रिटन स्टेटमेंट आई, अब जीवन बदलते रहता है. सी लाइफ इज ऑल अबाउट परिवर्तन, नथिंग एवर रिमेन्स द सेम. बाल उड़ जाते हैं, एवरीथिंग, बाल उड़ जाते हैं, शरीर कमजोर हो जाता है, शरीर बदल जाता है. सो द शरीर इज कॉन्स्टेंटली चेंजिंग and circumstances in life they are changing and the world is a whole lot of random. अब जब तक सिविल सूट चलेगा, outside of the courtroom things will change, and if things are changing, the plaintiff and the defendant, they are not really sure whether, even if the decree is passed in their favor, whether they will be able to have any use of it. मतलब आपने किसी से पैसे निकलवाने और सामने वाला आदमी जब तक आपका 10-15 साल का ट्रायल चला या सूट चला, बेसिकली चले, समरी में नहीं जाते. समरी इज गिवन इन ऑर्डर 37 बाय द वे, मतलब बार बार बोलते रहिएगा मेरे साथ साथ. और अभी तो हमने रिवीजन लेक्चर भी करना है, खैर इंटरिम ऑर्डर्स के बाद वाला करते हैं. तो आप चीज़ें बदलती रहती हैं. अब सामने वाला का दिवालिया निकल गया, उससे पैसे निकलवाएंगे कैसे? डिक्री तो कोर्ट ने पास कर दी कि हाँ, दिस गाय ओज यू मनी, इट हैज बीन प्रूव्ड इन अ कोर्ट ऑफ लॉ. Now what do? Well, you apply for execution, but the other person is just not in a position to pay it, because, and the other person was smart, he or she intentionally sold off their property before this trial ends ताकि वो property से इसको इधर से पैसा ना देना पड़ जाए. Right. So to prevent the abuse of process of court and to prevent the randomness of life, the court wants some certainty over, well, not the court that wants, the parties want some certainty, and in some cases, well, the court also wants some certainty. नहीं तो सारी मेहनत तो पानी फिर जाएगा. So they keep on passing interim orders कि भाई फाइनल तो जो होगा सो देखेंगे, इसके अंदर जरा हम काम करते हैं. So that, like for example, you are traveling up to वैष्णो देवी and आप वो बीच में, आई थिंक एक मिड पॉइंट आता है ऑफ दैट यात्रा. Always say it as a yatra, never call it as a trek or a hike, because it's not that, it's a yatra. तो यात्रा में एक मिड पॉइंट आता है, आई थिंक एक छत करके आती है, मैं इस टाइम नाम भूल गया उसका. तो दैट आप कह सकते हैं भाई इंटरिम तो आ गए ना, इंटरिम बीच में आ गया. ऑलराइट. सो इंटरिम का जो डिक्शनरी मीनिंग है, दैट इज फॉर द टाइम बीइंग. इट आल्सो मीन्स इन द मीन टाइम, बट प्राइमरली इट मीन्स टेम्पररी या नॉट फाइनल. तो ये पता नहीं है कि केस किसने जीता है या नहीं जीता. इट इज ऑलमोस्ट लाइक द फर्स्ट इनिंग्स हैज एंडेड इन अ क्रिकेट मैच, that you can call as interim. Alright. The main shabd that you have to mention in your answers whenever you're writing a short note on interim orders is intervening. So intervening का ही short form is inter, and यहाँ पे हमने in होना चाहिए था, interin नहीं, but it just doesn't sound good, right? So interim हो गया. Interim, or we call them as interlocutory orders, as given in order 39 primarily, but then there are certain more of the same nature. The more ones we'll do in this lecture, एंड देन जो इसके बाद जो मेन वाले जो इंटरलॉक्यूटरी ऑर्डर्स हैं वो अगले वाले लेक्चर में कर लेंगे, बिकॉज उसके अंदर मुझे आई हैव टू गिव यू डिक्टेशंस ऑफ ऑल ऑफ दीज कॉन्सेप्ट्स. Alright, so these interlocutory orders / interim orders, they are well passed during a pendency of a suit, because as remember TPA के अंदर भी the concept of lis pendens, something like that. So the pending, so litigation is pending, you want to prevent the circumstances, because life, it is all about change. You want to prevent those circumstances from changing a bit less than they usually do. That is what the primary purpose is. So proceedings which do not determine finally the substantive rights and liabilities of the parties in respect of the subject matter. ये चीज़ आप लिख लीजिए. I'll read it out again to you. Proceedings which do not determine finally the substantive right and liabilities of the parties in respect of the subject matter. Alright, आगे चलते हैं. Interlocutory, not that which decides the cause. This is not that which decides the cause, but that which only settles some intervening matters relating to the cause. जो मैंने अभी आपको ज्ञान प्रवचन पिछले बार दिया था फॉर्मल लैंग्वेज में, वो यही है. Alright. So now, from the time that the suit is instituted and from the time it is finally disposed of, this entire timeline, because it is long, because the courts are, when the job that you're applying for, कभी ये मत समझ लीजिएगा कि बस एग्जाम क्लियर हो गया और उसके बाद the life is very hunky dory and everything is fine. No, you have a lot of cases to look after, you have a lot of litigants coming to you. So purpose is to protect the subject matter of suit and to prevent the abuse of process. सामने वाला डिफेंडेंट जानबूझ के कह गया मेरे से क्या पैसे लेगा तो सब कुछ भेज दूंगा जैसे ही केस वेस लगेगा, या केस आगे चल रहा है और उसे पता है कि ही सेट टू लूज, वो अपनी प्रॉपर्टी पहले ही बेच गया और कह रहा है टटोल ले, जैसे हम हिंदी में यहाँ पे दिल्ली में स्लैंग टटोल ले भैया, टटोल ले इन द सेंस यहाँ से दोनों शोल्डर को पकड़ो और इसको ऐसे करो, देखो पैसे निकलते हैं कि नहीं, कुछ ही नहीं निकलेगा. दिस इज नॉट अ वीडियो गेम, नो. So to prevent the abuse of this entire process, you have interim orders. Now open your Bear Act to Order 24. This is payment into court. Order 24. This is one such kind of an interim order. Main stuff, as I've told you, is Order 39. But Order 24 is payment into court. Deposit by defendant of amount in satisfaction of claim. The defendant in any suit to recover a debt or damages may, at any stage of the suit. टेल मी प्री का क्वेश्चन दिखाई दिया कि नहीं दिखाई दिया. अगर प्री का क्वेश्चन दिखाई दिया है, होपफुली यू हैव अ डेडिकेटेड नोटबुक फॉर प्री एंड यू कीप ऑन राइटिंग कि कहाँ पे कौन सा क्वेश्चन है. If you are solely in the course and not in the judiciary batch, then it becomes even more important for you to do this exercise. क्योंकि judiciary batch वालों को तो मैं हर मॉड्यूल के अंदर कुछ ना कुछ बोलते हुए और रटवा ही लूंगा. अगर आप केवल CPC के कोर्स में अपनी प्री के लिए प्लीज नोट डाउन कर लीजिए. आप कहेंगे मैं तो कभी प्री देना ही नहीं, कल का क्या पता, और लिख लीजिए ना अपने नोट्स जब बना ही रहे हैं. when you paid the fee for the course, so why not just write down the notes. Deposit in court such sum of money as he considers as satisfaction in full of the claim. So for example, the suit is of debt or damages. अब दो तरीके का सूट है जिसमें मतलब सामने वाले ने नेट एक व्यक्ति से पैसा लेना है. अच्छा, लाइक फॉर एग्जाम्पल लेट अस से कि मैंने किसी से पैसे लेना है, मैंने मान लेते हैं आपसे पैसे लेना है, मुकुल मिश्रा जी से मैंने पैसे लेने. तो मुकुल मिश्रा जी ने क्या करा कि मैंने कहा मैंने तुमसे 15,000 रुपये लेने, वगैरह मैं 10,000 रुपये जमा करा रहा हूँ, मुझे लगता है आपको सिर्फ 10,000 के ही आप हकदार हैं, that you are the rightful owner of only 10,000 rupees and I need not pay you a penny more than that. Now that need not pay you a penny more than that, the court will decide. However, this guy can actually, this guy, the defendant primarily. अच्छा, एक और क्वेश्चन दिखाई दिया. Who will make this payment into a court? The defendant. Deposit in court such sum of money as he considers satisfaction in full of the claim. वो कह रहा है, मिश्रा जी कह रहे हैं that yes sir, I agree that I owe you money. However, either now he has two options. Either he can pay out the full 15,000 and the matter is done and over, then I'll accept it. However, if he pays 10,000, now I have two options. I can either accept कि हाँ भाई ठीक है चलो 10,000 रुपये हो गया, बाकी तो इतना नहीं तो वकील का खर्चा ही करूंगा. बट अगर मैं ईगो इशू बना के बैठ जाऊं और कहूँ नहीं ये मेरे 5,000 रुपये और देगा, चाहे मुझे 1,00,000 रुपये और वकील को और ट्रायल में देने पड़े, तो उसके अंदर फिर दैट आई लीव इट टू द कोर्ट. तो मिश्रा जी कैन डिपॉजिट इनटू द कोर्ट. सो दिस इज अभी तो अच्छा. एंड व्हाई डज दिस हैव द कैरेक्टर ऑफ एन इंटरिम ऑर्डर इज बिकॉज अभी तो केस चल रहा है ना और आप ऑलरेडी जान छुड़ा रहे हैं केस से. तो दिस इज अ नेचर ऑफ एन इंटरिम ऑर्डर. In nature of an interim order, notice of deposit. Notice of deposit shall be given through the court by the defendant to the plaintiff. Through the court. कोर्ट को बोल देगा इसको बोल दो कि पैसा आ गया. Alright. And the amount of the deposit shall, unless the court otherwise direct, be paid to the plaintiff on his application. So plaintiff will have to make an application कि please मुझे ये पैसे दे दो. चलो ये वाले तो दो, बाकी तो बाद में देखेंगे. Interest on deposit not allowed to plaintiff after notice. No interest shall be allowed to the plaintiff on any sum deposited by the defendant from the date of receipt of such notice. Whether the sum deposited is in full of the claim or falls short thereof, no questions really from here. Procedure where plaintiff accepts deposit as satisfaction in part. Where the plaintiff accepts such amount as satisfaction in part only of his claim, he may prosecute for his suit for the balance. अब 5,000 रुपये के लिए पहली बात तो खैर कौन ही सूट आगे करेगा, but however people tend to do it. So now you have an option. As the plaintiff, you have two options. Either you accept it in full or you may prosecute the suit for the balance. And if the court decides that the deposit by the defendant was a full satisfaction of the plaintiff's claim, court ने decide कर लिया later on कि भैया ये तो 10,000 ही थे. The plaintiff shall pay the cost of the suit incurred after the deposit and the cost incurred previous thereto as so far as they were caused by excess in the plaintiff's claim. मैं 5,000 रुपये के लिए भिड़ गया सामने मिश्रा जी से, कल को कोर्ट ने कहा 10,000 ही बनते थे तुम्हारे. Now, post the date of the deposit, whatever costs Mishra ji had to incur of his lawyer, of the application fees, of the document fees to continue the trial, the plaintiff will have to pay. Oh बाप रे बाप, राइट? तो अगर आप नेचर फिर से सिविल सूट का देखेंगे, सारा खर्चा तो प्लेंटिफ, मतलब मेनली वो कह रहा है अच्छा तुम आए हो शिकायत करने आए हो, ओ पैसा लो, कोर्ट फीस अलग भरोगे, समन्स की फीस अलग भरोगे, वकील की फीस अलग भरोगे, और सामने अगर सामने वाले ने ऐसे पैसे जमा करा दिए और कल को आपने कहा नहीं मैं तो और लड़ूंगा, उस डेट, उस जमा कराने की डेट के बाद अगर कोर्ट सामने वाले के फेवर में डिसाइड करेगा कि हाँ भाई, मतलब एक्चुअली तो कोर्ट आपके फेवर में डिसाइड कर रहा है कि यस द अदर पार्टी ओज यू मनी, बट जो बोलने का तरीका ये है कि अगर कोर्ट डिसाइडिंग कि हाँ सामने वाले ने ठीक जमा कराए थे, जिस दिन वो जमा की डेट होगी उसके बाद जितना खर्चा होगा आप भरेंगे एज अ प्लेंटिफ। मैं फिर से आपको एक्सप्लेन कर देता हूँ, होपफुली इट इज क्लियर, वैसे तो क्लियर हो जाना चाहिए बट ठीक है, मान लेते हैं जी ए वर्सेस बी हो रहा है एज यूजुअल। ए वर्सेस बी में अभी मैंने इलस्ट्रेशन लिखी भी हुई है 15,000 वाली, बट इसको यहीं से दोबारा समझ लेते हैं। ए वर्सेस बी, चलो जी 35,000 करते हैं, थोड़ा महंगाई का जमाना है, इन्फ्लेशन है तो कोई बात नहीं, 35,000 का काम करते हैं। I'll just check whether my mic is working. Yes it is. And you deposited 25,000, alright, and I, or rather A, plaintiff भैया, decides कि no, he wants to continue the suit for 10,000 more. Now judge decides कि 25,000 is the amount to be paid to A. Alright, this was okay. That जो डिफेंडेंट ने जमा कराया था it was absolutely okay, and judge like courtroom, the court has decided that this is going to happen. And मान लेते हैं B then, अब 25,000 से इन्होंने 1/4/23 को ये 25,000 रुपए जमा करा दिए कोर्ट में, एंड द सूट एंड्स एट 1/4/25। 2 साल का खर्चा ऑफ बीज लॉयर टू कंटिन्यू द सूट इज 50,000। ए विल पे दिस अमाउंट टू बी, वो कह रहे हैं एक तो तुम्हें 25,000 तो नुकसान हो गया ना आपका, इसीलिए यूजली लोग सेटल आउट कर लेते हैं। However, but this शर्त is only when the court says कि हाँ 25,000। If the court tomorrow says कि no 35,000 ही जाने चाहिए थे प्लेंटिफ भैया को, तो कोई बात नहीं, 35,000 जाएंगे, फिर कोई कॉस्ट वॉस्ट नहीं जाएगी। Alright. Now procedure where he accepts it as satisfaction in full, wherein the plaintiff is accepting कि चलो इतने यहाँ के बहुत बड़ी बात है, इतने कंजूस आदमी से इतने भी कहाँ से आए हैं। Where the plaintiff accepts, no, I'm not saying anything about Mukul, I'm saying A versus B, वो जो कंजूस आदमी, that is defendant. Where the plaintiff accepts such amount as satisfaction in full of his claim, he shall present to the court a statement to that effect, and such statement shall be filed, and the court shall pronounce judgment accordingly. And in directing by whom the costs of each party are to be paid, the court shall consider which of the parties is most to blame for the litigation. मेरा अगर तुमने पैसे देने ही थे तो पहले ही दे देते, और अगर तुमने एक्सेप्ट करना ही था तो वो बाहर भी तो अपने आप आपस में सी। द कोर्ट डज नॉट लाइक इट्स टाइम टू गेट वेस्टेड। द कोर्ट एक्चुअली इन सिविल सूट, देखिए अगर आप ओवरऑल पूरी की पूरी एक तरह से लीगल सिस्टम की ओरिएंटेशन देखेंगे ना, सरकार कहती है यार अपने आप ही निपटा ले, दैट इज व्हाई एडीआर एंड एवरीथिंग एल्स इज देयर, नो अल्टरनेटिव डिस्प्यूट रेजोल्यूशन मैकेनिज्म। बट लोग अकड़ैल हैं, एक पार्टी हमेशा सुलटाना चाहती है, दूसरा नहीं सुलटाना चाहता, तो वो दूसरे को सर पे लट पिटाई करने के लिए द कोर्ट इज सिटिंग देयर। बट कोर्ट को ये बात पसंद नहीं है। कोर्ट एक्चुअली शुड बी मतलब कोर्ट्स आर एक्चुअली इंटरेस्टेड इन मोर इन क्रिमिनल मैटर्स, more towards constitute, more towards other serious stuff. Okay, ये आपस का है, आपस में निपटाओ, लेकिन लोग मानते नहीं हैं। That is why the punitive system, the punitive aspects in civil suits are there. ठीक है जी, hopefully this is clear to you. अब ये illustration आप A, B और C तीनों मार्क कर देंगे, since they are illustrations, so they are standard set pre के questions. Let us read them. A owes ₹100. अब यार आज का ये तो खैर उस जमाने में तो जब ये लिखी होगी तब तो 100 रुपये बहुत बड़ी बात होती होगी। B sues A for the amount, having made no demand for payment, having no reason to believe that the delay caused by making a demand would place him at a disadvantage. On the plaint being filed, A pays the money into court and under order 24. B accepts it in full satisfaction, but the court should not allow him any cause, the litigation being presumably groundless on his part. Remember, he did not make any demand for payment. क्या पता अगर कर देता तो A अपने आप पैसे देता, क्योंकि A ने तो immediately as per order 24 में application लगा और कह रहा है लो पैसे अपने. Therefore B will not be entitled to any costs. Hopefully you've understood the funda. B is there under the circumstance mentioned in illustration A. On the plaint being filed, A disputes the claim. Afterwards, A pays the money into court. B accepts in full satisfaction. The court should also give B his cost of suit. लिखा हुआ actually cost होना चाहिए. Cost of suit, A's conduct having shown that the litigation was necessary. अब इसके अंदर A बदतमीजी कर रहा है और litigation के बिना पैसे नहीं देता, तो इसीलिए फिर जैसे ही पैसा आया ए ने पहले डिस्प्यूट करा, फिर ए मान गया, अरे भैया तो फिर पहले डिस्प्यूट क्यों करा था. तो बेस्ड ऑन द कंडक्ट ऑफ द डिफेंडेंट द कॉस्ट टू द प्लेंटिफ्स विल बी डिसाइडेड. तो इसीलिए जब भी आप जज बने तो पहले देख लीजिएगा कि इनमें से बदतमीज आदमी कौन है, और बदतमीज से थोड़े से कॉस्ट उधर कर देना, मतलब पूरा ही बदतमीज वाले आदमी को भी बैंक्रप्सी ना दे देना. A owes rupees 100 and is willing to pay him that sum without suit. All right. And is willing. B claims rupees 150, sues A for that amount. Okay. On the plaint being filed, A pays 100 into court, immediately disputes only his liability to pay the remaining 50. B accepts rupees 100 in full satisfaction. The court should order him to pay A's costs. Of course, the court will want to order A. भाई देखना illustration दोबारा देखना, बड़ी प्यारी सी illustration है. A owes B rupees 100 and is willing to pay him. शरीफ आदमी है, A कह रहा है यार प्लीज यार अपने पैसे ले क्यों जाते हैं कोर्ट. वो फिर भी पहुंच गया और कोर्ट में जाके कह रहा है चलो 100 रुपए मांगूंगा, तो कोर्ट तो शायद 100 ना दे, 80 अवॉर्ड करेगा, 150 मांग लेता. ए कहता है, ए इमीडिएट जाता है, प्लेंट फाइल हुई, ए ने सीधा 100 रुपए जमा कराए और कह रहा है भाई ये 50 रुपए किस बात के. B accepts that rupees 100 in full satisfaction of his claim. The court should order him to pay his costs. It's as simple as that, isn't it? All right. So illustration यहाँ पे ये करते हैं, एक और करते हैं. अच्छा बाय द वे आज वो हो गया, पास हो गए आपके, नई आईपीसी, नई सीआरपीसी, नई एविडेंस अब करते हैं, कोर्स के अंदर करेंगे. ए वर्सेस बी, 15,000 रुपए में बी डिपॉजिट्स 10,000 रुपए, और इफ ए एक्सेप्ट्स इन फुल, जजमेंट टू फॉलो एंड द केस इज गॉन एंड ए इन पार्ट, देन 5,000 रुपए. बट मतलब अगर ए को और 5,000 रुपए चाहिए, लेकिन अगर हार गया इन द सेंस अभी भी केस तो जीतेगा ही, बिकॉज 10,000 रुपए तो मिल ही रहे हैं, लेकिन 5,000 रुपए के लिए tomorrow the court decides no, this guy should only get 10,000. Guess who pays the costs for B? Yes, Mr. A will pay the costs. So if the court ultimately decides that A is entitled only to 10,000, well, the cost to be, then well, you have incurred all the costs that you have incurred post the deposit of 10,000 will be paid. Now object लिख लीजिए. Object, as it is open to the plaintiff to abandon the suit, therefore open for defendant to in a suit for debt or damages to deposit in a court at any stage of the suit. I'll repeat it. You can pause the lecture. You can take down the note. The objective, as it is open for the plaintiff to abandon the suit, by therefore it is open for defendant to in a suit for debt or damages to deposit in court at any stage of the suit कि भैया प्लीज इसको खत्म करते हैं मामले को. ठीक है जी, होपफुली इट इज क्लियर. तो यहाँ पे होपफुली वी हैव फिगर्ड आउट ऑल प्री के क्वेश्चंस. नो, एवरीथिंग इज डन. ऑलराइट, एंड देन यू कैन प्रैक्टिस आउट फ्रॉम योर later on. अभी नहीं, when I instruct you in our I'm talking specifically to the judiciary batch. When I instruct you in the WhatsApp batch, when the CPC lectures are over, immediately आप प्री के एक राउंड मार देंगे अटेम्प्ट का उन क्वेश्चंस पे. ऑलराइट, ऑल ऑफ देम आर लाइंड अप in our prelims का क्वेश्चन बैंक. ठीक है जी. Now you go for another similar provision is order 25, security for costs. Order 25 security for costs पे जाते हैं. Open it in your bare act. When अगला ही order है. When security for costs may be required from plaintiff at any stage of a suit. Pre का question दिखा कि नहीं दिखा. All right. The court may either of its own motions suo moto, right, or on the application of any defendant. Pre का question दिखा कि नहीं दिखा. Based on the discussion that we have had in our previous lectures, I may just put out this lecture on YouTube. So if you're watching this on YouTube, we are, well, the students and I are constantly dissecting what all can be asked in pre. So we are referring to, well, our previous notes. All right. So At what stage? At any stage. Who can, well, get you to pay security for costs that as in may be required for the plaintiff into the court? The court can either of its own motion, the court has the power, yes, or on the application of any defendant. वहां पे एक option C होगा plaintiff, application of any plaintiff. अरे plaintiff अपने आप से ही cost कैसे करेगा, right? So that is how you can eliminate that option. Order the plaintiff for reasons to be recorded to give within the time fixed by it security for the payment of all costs incurred and likely to be incurred by any defendant. अब ये रियल लाइफ में उतनी आसानी से काम नहीं करता. However, we don't care about real life right now. We are primarily oriented towards clearing the exam, which is primarily academic in nature. Right, so we won't go into those discussions. At any stage of a suit, the court may either of its own motion or on the application of any defendant, या तो defendant बोल दे या कोर्ट को खुद थोड़ी plaintiff के ऊपर थोड़े से कह रहे जी आपके ऊपर थोड़े से dark clouds घूम रहे, जरा इधर आओ. Order the plaintiff for reasons to be recorded to be given within the time fixed by its security for the payment of all costs incurred and likely to be incurred by any defendant. क्योंकि कल को अगर नहीं भी देता, सिविल प्रिजन की भी लिमिटेशन वो 3 महीने मैक्स की है, और मतलब बहुत बहुत कम टाइम फ्रेम है ना सिविल के अंदर. तो कल को अगर कॉस्ट उनके ऊपर लगा भी दी गई, जो कि डिफेंडेंट साहब ने अपनी लिटिगेशन करी है, वकील साहब, देन द टाइम टू कोर्ट, द मेंटल हैरेसमेंट एटसेट्रा, तो वहाँ पे नेट देखिए जीवन क्या है. वैसे जीवन इज ओनली ऑल अबाउट द कॉस्ट्स, है ना, सामने वाले से कॉस्ट ही लेनी. तो दिस इज दैट प्रोविजन. तो ये अभी केस चल रहा है और हमें लग रहा है अगर कोर्ट सेटिस्फाइड है या डिफेंडेंट की एप्लीकेशन पे कोर्ट सेटिस्फाइड है, देन वो प्लेंटिफ को कह सकता है कि सुनो इधर आओ, इनका इतना खर्चा हो रहा है, कल को तो मुझे नहीं लग रहा कि तुम दे पाओगे, तो अभी के अभी जमा करा दो ना. इट इज एज सिंपल एज दैट. ऑलराइट. Provided that such an order shall be made in all cases in which it appears to the court that a sole plaintiff is, or when there are more plaintiffs than one, that all plaintiffs are residing out of India. So this is a compulsory condition, shall be. Usually all of our provisions in the CPC are there directory in nature, but this one is compulsory. If the plaintiffs are residing out of India, क्योंकि कल को इनको पकड़ कौन पाएगा. और मुझे बताइए प्री का क्वेश्चन दिखा कि नहीं दिखा, दिख गया होगा, दिखना ही चाहिए कि किस कंडीशन में दिस ऑर्डर शैल बी मेड, दैट प्लेंटिफ्स आर रिसाइडिंग आउट ऑफ इंडिया, दैट सच प्लेंटिफ डज नॉट पोजेस, दैट नो वन ऑफ सच प्लेंटिफ पोजेसिव एनी सफिशिएंट रिमूवेबल प्रॉपर्टी विद इन इंडिया अदर देन द प्रॉपर्टी इन सूट. कि इसके अलावा तो ये इनके पास कुछ है ही नहीं. सो दे आर टेक्निकली स्पीकिंग रोमिंग अराउंड लाइक फ्री मैन एंड दे आर लाइक जो करना है हमारा कर लो, हमारा तो वी डोंट केयर. तो वो कहते हैं पहले इनको पकड़ लेते हैं. ऑलराइट. Whoever leaves India under such circumstances as to afford reasonable probability that he will not be forthcoming whenever he may be called upon to pay costs shall be deemed to be residing out of India within the provision of sub rule 1. Alrighty. So ये तो ये वाला काम हो गया, राइट. तो अगर आप लग रहा है कि यार ये तो वैसे भी बाहर ही रहता है, इसने कौन सा आना ही है, लाइक फॉर एग्जाम्पल अब आर पंजाबी इन कैनेडा एंड अगर यहाँ पे कोई सिविल सूट चल रहा है, सो द कोर्ट कैन बेसिकली प्रिज्यूम. अच्छा, और मान लेते कोई बहुत बाहर जा रहा है और बहुत आ रहा है, देखिए reasonable probability that he will not be forthcoming whenever he may be called upon to pay costs. और कोर्ट को लग भी रहा है कि यार ये हारेगा केस, थोड़ा बहुत लग रहा है. Of course it's not moving towards final judgment as in not pre-deciding the case, but लग रहा है कि यार कल को अगर इससे कॉस्ट मांगी तो दे नहीं पाएगा या देगा नहीं, तो कोई बात नहीं, पहले ही जमा करवा लेते हैं. Alright. Effect of failure to furnish security. In the event of such security not being furnished within the time fixed, the court shall make an order dismissing the suit unless the plaintiff or plaintiffs permitted to withdraw therefrom. So another scenario in which the suit is being dismissed, right? और ऐसे हम 2-3 scenario देख चुके हैं. Alright. Where a suit is dismissed under this rule, of course अब हमें check करना पड़ेगा whether it serves as a res judicata or not. As usual, section 11, the plaintiff may apply for an order to set the dismissal aside, and if it is proved to the satisfaction of the court that he was prevented by any sufficient cause from furnishing security within the time allowed, the court shall set aside the dismissal upon such terms as to security costs or otherwise it thinks fit, and shall appoint a day for proceeding with the suit. The dismissal shall not be set aside unless notice of such application has been served on the defendant. I believe I do not need to make a comment here. I believe it should be clear, but ठीक है, थोड़ा सा just उसको हल्का सा elaborate कर लेते हैं. Where a suit is dismissed under this rule, the plaintiff may apply for an order to set the dismissal aside. So can you apply? Yeah, of course you can. अगर मतलब मान लेते हैं that plaintiff was ordered to pay the security into the court and he couldn't, and the suit is dismissed because usually the plaintiff की default punishment क्या है CPC में, सूट हटाओ, तुमने खुद तो तुमको, यू आर नॉट इंटरेस्टेड इन द केस इटसेल्फ, वैसे भी वी आर आल्सो इंटरेस्टेड इन as less cases as possible in the courtroom, so therefore bye bye. So if we do bye bye, then you are allowed to, well, you do allowed to apply for an order to set the dismissal aside, और फिर अगर ऐसा कुछ हो रहा होगा, the dismissal shall not be set aside unless notice of such application, अब plaintiff की application आ गई तो defendant के ऊपर सर्व कर दो कि भाई देखो आ गया, क्या पता दोबारा से केस शुरू होने वाला, ऑलराइट. And similar provision is order 41 rule 10 is security for cost of appeal also as well is included, but ये हम वहाँ पे कर लेंगे जो हमारा अपील और रिविजन वगैरह वगैरह वाला जो लेक्चर आएगा अभी थोड़े से, आई थिंक 3-4 लेक्चर के बाद वो आना है, और फिर तब वहाँ पे उसको डिस्कस. सो objective of this is to secure or protect defendant in event of success that they may have difficulty realizing their costs from plaintiff. Hopefully the core funda is clear now. Anytime that they ask you a question in DJS mains, any fictional sort of a question ever from this situation, you know what to write, and bare act तो सामने पड़ी ही होगी, which all orders, so order number, rule number सब कुछ बड़ी clearly लिख कर आना ही आना. Alright, now we go to commissions, usually हमारे civil suits के करता धरता. Alright, commissions I think अगर आप YouTube पे देख रहे हैं, may just edit this portion of the lecture out, but any which way we'll just decide later on. अगर आप YouTube पे देख रहे हैं, so treat this as a demo lecture of the CPC course. We'll of course leave the link down below in the comments. If you're watching this on the course, let us continue. Order 26 पे आ रहे हैं commissions to examine witnesses. It always has to be read with 75, and tomorrow my mind changes that I want to post the full lecture on YouTube. Well then YouTube वाली जनता यहाँ पे देख सकती है. And of course, for further lectures, check the pinned comment as always. Now, cases in which court may issue commission to examine witness. Any court, alright, may in any suit, okay, issue a commission for the examination on interrogatories. What were interrogatories? The list of questions as we discussed in the last lecture, or otherwise of any person resident within the local limits of jurisdiction who is exempted under this court from attending the court, or who is from sickness or infirmity unable to attend it. Now अब कह रहा है who is exempted, तो ऐसी कहीं ना कहीं पे list होगी. Usually people who are unable to, let us say आर्मी में कहीं पोस्टिंग है, बहुत सीनियर सरकारी अफसर है, बहुत ज़्यादा इल है, या परमहंस है, is like absolutely naked, दिगंबर साधु है, आएगा ही नहीं कोर्ट में, आपकी मोरालिटी ऑफेंड हो जाएगी, तो उनके लिए वो कह रहे हैं ये काम कर सकते हैं, इनके लिए कमीशन. सो यूजली जो LCs जिसको हम प्रैक्टिस में कहते हैं, तो वहाँ पे technically speaking it is just like delegating a power. However, the court cannot delegate its judicial functions, but ये जो छोटे मोटे ancillary काम है, it can appoint a commission and just get the job done. So issue a commission for the examination on interrogatories or otherwise of any person. So usually जैसे like साकेत कोर्ट वगैरह में जो टॉप फ्लोर पे, I think on the 7th odd floor, usually you will see आपके LCs sitting out for examination and cross वगैरह जो वहाँ पे चलती रहती है in front of a LC. Alright. अच्छा, तो ये तो this is talking about the cases in which the court can do so. Now order for commission explanation you can read on your own. I do not even need to explain it. It is as simple as that. Rule 2, order for commission. An order for the issue of a commission for the examination of witness may be made by the court either of its own motion or on the application supported by affidavit or otherwise of any party to the suit or of the witness to be examined. तो यहाँ पे 3 लोग आ गए for pre का हमारा क्वेश्चन बन गया. pre का क्वेश्चन क्या बना है, ये आपका ये order for a commission, who can apply for it? So either can the court order it of its own motion suo moto, yes, or on the application supported by affidavit of who, plaintiff or defendant of any party to the suit, और एक तीसरी कैटेगरी आ गई of the witness. पॉज करके अपना शॉर्ट नोट बना लीजिए अपनी प्री की नोटबुक में. ऑलराइट, नाउ okay, this is okay, order rule 3 is okay, but I want to focus on the question. Person for whose examination commission may issue. Any court may in any suit issue a commission for the examination on interrogatories or otherwise of any person resident beyond the local limits of his jurisdiction. कोई भी जो बाहर रहता है beyond the jurisdiction. Any person who is about to leave such limits before the date on which he is required to be examined in court, वो पहले पता ही है कि यार इसको वहाँ पे जाने वाला, तो कोई बात नहीं, अपॉइंट करें कमीशन और इनका पहले से काम करा के रख लें, इनका जो इंटरव्यू जो हम कहते हैं एग्जामिनेशन पहले से करा के रख लें. Now this order and rule has to always be read with Rule 75, alright? So Part 3, Incidental Proceedings and Commissions. Section 75, you always have to mention this in your answers. Power of court to issue commission. Subject to such condition limitation as may be prescribed, the court may issue a commission to examine any person, to make a local investigation, to examine or adjust accounts, to make a partition. This is the most common thing, and this is perhaps what you need to know as a person who is applying for the job of a judge. To hold a scientific, technical or expert investigation, you can apply for commission. अब मुझे बताएं प्री का क्वेश्चन दिखाई दिया कि नहीं दिखा? पूरा यही कर देगा. Subject to conditional limitations, the court may issue a commission in which of the following cases? Well, here are the cases. Alrighty. And to conduct sale of property which is subject to speedy and natural delay and which is in the custody of the court pending the determination of the suit, to perform any ministerial act. कोई इस पे commentary की ज़रूरत नहीं. All of this is free. Alright. Commission to another court. Now, actually you need not even do that. These are like very, very simple provisions. We will be skipping these and we'll be moving ahead actually. And we'll go for the essential ones. Now we resume the order and rule. Come back from 75. Come back to here. Any person in the service of the government, जो कि list बना रहे थे, who cannot in the opinion of court attend without deterriment to the public service. बहुत बिजी आदमी है सरकारी नौकरी में, तो नहीं आ पा रहा, तो कोई बात नहीं, कमीशन बुलाओ और एग्जामिनेशन करा लो इंटरोगेटरी पे. एग्जामिनेशन मतलब बैठ के एग्जाम तो नहीं देगा, बट द पर्सन इज गोइंग टू बी एग्जामिन्ड इन फ्रंट ऑफ अ कमीशन. ऑलराइट, नाउ आगे चलते हैं. Commission for examination of any person resident within the local limits of the jurisdiction of the court, notwithstanding anything contained in these rules, any court may, in the interest of justice or for the expeditious disposal of the case or for any other reason. So this is very, very wide. This power is very wide to the court. Issue commission in any suit for the examination on interrogatories or otherwise of any person resident within the local limits. So usually this is used, and therefore this becomes a thing that you may want to rote learn. Rule 4A of this order. Alright. Rule 4A, commission for examination of any person resident within the local limits. Now usually this is used and the commission is formed. Commission usually एक ही आदमी, and उसके सामने फिर सारा का सारा काम अपना करा लिया जाता है. Alright. Then it goes into different रूल्स. आपने कुछ रटना नहीं है, कुछ नहीं काम करना, शांति में आप आराम से आप बैठें, बट आपको यहाँ तक तो बिल्कुल पता होना चाहिए. राइट. कमीशन टू मेक लोकल इन्वेस्टिगेशंस, वी नीड नॉट डू दैट. कमीशन फॉर साइंटिफिक इन्वेस्टिगेशन, प्रोसीजर ऑफ कमिश्नर. द commissioner, after such local inspection and after reducing writing, taking the evidence by, shall return such evidence together with his report in writing signed by him to the court. That is his main job. बाकी जजमेंट वगैरह तो सारा कोर्ट करेगी, राइट, बट जो मेन जो आपका जो एविडेंस कलेक्शन हमने नीचे कमीशन के ऊपर दे दिया. एंड यहाँ पर आ जाए 10C में, रूल 10C के अंदर, सिंस ऑफ कोर्स लेटर है तो अमेंडमेंट से आ रहा होगा. कमीशन फॉर द सेल ऑफ मूवेबल प्रॉपर्टी, wherein any suit it becomes necessary to sell any movable property which is in the custody of the court pending the determination of the suit, which cannot be conveniently preserved. The court may, for the reasons to be recorded, is of the opinion that, well, it is in the interest of the justice to do so, so issue a commission to such person as it thinks fit, directing him to conduct such sale. ठीक है जी, okay. The more I am taking you through only to the most commonly used provisions. Commission to examine accounts, same thing. Alright. तो कोर्ट के पास इतना टाइम नहीं है क्योंकि केस बहुत सारे हैं, so it keeps on appointing commissions, keeps on doing its work, and ये जो ancillary एक तरह से delegation ही है ये. Alright. Now perhaps ये आपको रूल याद रखना है, Rule 13. Alright, under this order. Give me 1 second, I'll just check whether I've not left out anything. I'm sure that I haven't. Section 75 जरूर याद रखना ही रखना है, because section 75 has to be mentioned. Okay, I think that is okay. Now आगे चलते हैं. Rule 13, commission to make partition of immovable property. Mostly civil cases, the major ones, well, they are for partition of immovable property. Where a preliminary decree for partition has been passed, the court may, in any case not provided for by section 54, issue a commission to such person as it thinks fit to make the partition. So who makes the partition? The court asks who? Well, a commission, alright. Or separation according to the rights as declared in such decree. तो पहले decree, preliminary decree pass हो जाए और उसके बाद as per order 26 rule 13, well, the court can order or can issue a commission to such person as it thinks fit. Alright, procedure of commissioner. The commissioner shall, after such inquiry as may be necessary, divide the property into as many shares as may be directly by the order under which the commission was issued, and shall allot such shares to the party, and may, if authorized thereto by said order, award sums to be paid for the purpose of equalizing the value of the share. ये हाल तो तब है जब साथ कुछ जाना नहीं है, इतनी लड़ाई और इतनी मार काट, और अगर साथ में कुछ जाना होता तो पता नहीं इंसान एक दूसरे का क्या ही कर देता. All right. And then, well, of course, the commissioner will submit it to the court, sign it, and of course it has to be the final award has to be confirmed by the court. Again, पैसे कौन भरेगा commission के? Court तो उठाएगा नहीं खर्चा. Before issuing any commission under this order, the court may order such sum, if any, as it thinks reasonable for the expense of the commission to be within a time to fix paid in the court by the party who will pay, by the party at whose instance for whose benefit the commission is issued. प्री का सवाल दिख गया कि नहीं दिख गया? Who will pay the expenses of the commission? By the party at whose instance or for whose benefit, not आपके applicant पे, but for your benefit this was done, then you will pay the commission की costs. All right. Alrighty. And yeah, nothing much from here. Mostly practice related provisions, so we need not enter into those waters right now. So ये चीज़ ज़रूर लिख लीजिए. A judicial function of a court, so this goes till, or I think rule 22, a judicial function of a court cannot be delegated to a commission. Thus no commission can value the property in dispute. The commission can be appointed to gather the data to determine the value of the property. So this is what limitation does not relate to the Limitation Act, the word limitation in this context. Now you go to order 38. Open your BERAC to order 38 right before order 39, which is the subject of our next lecture. Order 38 rule 1, where arrest before judgment, अरे बाप रे, तो ये तो serious हो गया ना मामला. Where defendant may be called upon to furnish security for appearance, where at any stage of a suit, again this you need to know because these are standard pre-K questions. Within a suit of nature referred to in section 16 clauses A to D, open BERAC and say what was referred to in 16A to D, because that is a bar to this order and rule. The court is satisfied the affidavit or otherwise that the defendant with intent to delay the plaintiff or to avoid any process of the court or to obstruct or delay the execution of decree that may be passed against him has absconded or left the local limits. भाग ही गया भाई, मोटा अमाउंट क्या पता कल को देना पड़ जाए, वो पहले भाग ही गया. Is about to abscond or leave the local limits, has disposed or removed from the local limits of jurisdiction the court the property or any part thereof. Property भी बेच दी या बेचने लगा है. That the defendant is about to leave India, बिल्कुल इंडिया ही छोड़ के भाग रहा है कि पकड़ लो, फिर कौन सा सिविल केस लगाओगे. That the plaintiff will or may thereby be obstructed or delayed in the execution of any decree that may be passed against the defendant's suit. The court may issue a warrant to arrest the defendant and bring him before the court to show cause why he should not furnish security for his appearance. कह रहे इसको अरेस्ट करके लेकर आओ, वारंट इशू हो गया, और इसको जरा कोर्ट में आके बोलोगी जी किस खुशी में आप सिक्योरिटी नहीं देंगे, पेमेंट इनटू द कोर्ट, राइट? नहीं, पेमेंट इनटू द कोर्ट एज इन नॉट रेफरिंग टू ऑर्डर 24 बिकॉज दैट्स अ डिफरेंट कॉन्सेप्ट. Provided that the, technically speaking, isn't it bail, right? Provided the defendant shall not be arrested if he pays to the officer entrusted with the execution of the warrant any sum specified in the warrant as sufficient to satisfy the plaintiff's claim. वारंट के अंदर लिखा हो कि 10,000 रुपये अगर दे दोगे तो जमा हो जाएंगे, तो नहीं आना पड़ेगा कोर्ट में. एंड सच सम ऑफ कोर्स आना तो पड़ेगा ही बिकॉज द सूट हैज टू बी डिस्पोज्ड ऑफ. सच सम शैल बी हेल्ड इन डिपॉजिट बाय द कोर्ट अंटिल द सूट इज डिस्पोज्ड ऑफ अंटिल द फर्दर ऑर्डर ऑफ द कोर्ट. बेसिकली हम क्या कर रहे हैं कि हमें लग रहा है ये भाग जाएगा तो इसको पहले से ही अरेस्ट कर लो. Alright. Security. Where the defendant fails to show such cause, the court shall order him either to deposit in court money or other property sufficient to answer the claim against him, or to furnish security for his appearance at any time when called upon while the suit is pending, and until satisfaction of any decree that may be passed against him in the suit, or make such order as it thinks fit. Alright. So under the provisions of the last preceding rule. Now आगे चलते. This I believe is self-explanatory. But however, hopefully you've understood what is the object of this. Right. More important for your exam is Order 38 Rules 5 to 13, attachment before judgment. That is the more common thing to do. So its classic case law is Sardar Govind Rao versus Devi Sahai, in which the primary objective was detailed out for attachment before decree is, well, the party has to be in a position to satisfy the decree. Alright. Where at any stage of a suit, the court is satisfied by affidavit or otherwise that the defendant intend to obstruct, is the same rule, just that is about to dispose of. तो अगर वो अपनी प्रॉपर्टी बेचना just is about to, let us say वो बयाने के agreement में enter कर दिया, ATS बना के, agreement to sale बना के, is about to remove the whole or any part of his property from the local limits of the jurisdiction of the court. Let us say that the court is satisfied that this is happening, that the defendant जो इसने property बेच के सामने वाले के पैसे देने थे या property सामने वाले को ही दे देनी थी in a sense, मतलब बोलने के लिए, then the court may direct the defendant within a time to be fixed by it. So there is no 7 days, 15 days, 30 days. The court will fix the time either to furnish security in such sum as may be specified in the order, to produce at disposal of the when required the said property or the value of the same. मतलब जितने पैसे चाहिए वो सीधा साधा नोटिस फर्निश कर दिया जाएगा कि प्लीज जरा आ जाओ. Alright. The plaintiff shall, unless the court otherwise direct, specify the property required to be attached and the estimated value thereof. तो plaintiff के ऊपर ड्यूटी डाल दी कि बताओ जी कौन सी प्रॉपर्टी. If the court may also in the order direct the conditional attachment of the whole or any portion of the property so specified. If an order of attachment is made without complying with the provisions of Rule 1 of this rule, such attachment shall be void. Now what is attachment? कि अब आप कुछ नहीं कर पाएंगे उस पर. So technically speaking, it is obstructing the alienation rights of the defendant. Alright. Now this is absolutely crucial, because this is like major stuff. Now this power is, अगर मैं वैसे constitutional morality और इन सब में बात करूँ, technically speaking it violates, even I can make the argument, it violates the right to property. Okay, now it's no longer a fundamental right because it was removed by the 44th Amendment 1978, placed in Article 300A. Right, we always keep on revising stuff, so it's that. However, this is huge. These powers, arrest, because arrest also will violate your Article 21 in a sense, without getting into the morality and technicality of the debate or discussion. However, this is huge, so this should be used very sparingly. Alright. So the remedy of attachment before judgment is an extraordinary remedy. It should be exercised sparingly and it limits the ownership rights. Alright. तो अच्छा, और उसके बाद फिर attachment where cause not shown or security not furnished. अच्छा, एक बारी मैं यहाँ पे कर देता हूँ so that you can pause the lecture and you can make a note of it if you wish to. Alright. Now let us go for rule 8. Adjudication of claim to property attached before judgment. Where any claim is preferred to attach. Removal of attachment. I think this is more important. Removal of attachment when security furnished or suit dismissed. Where an order is made for attachment before judgment, the court shall order the attachment to be withdrawn when the defendant furnishes the security required together with security for the cost of the attachment, or when the suit is dismissed. मतलब काम हो गया हमारा, पैसे वैसा आ गया और पैसा नहीं आया तो कोई बात नहीं, अगर सूट डिसमिस वगैरह हो गया, so attachment of course will get removed. So order 38 is attachment. आदमी 38 का हो गया, अटैच होना शुरू हो जाता है, मिड लाइफ क्राइसिस आ जाती है. Classic case law for this is Premraj Mundra versus Muhammad Manek Ghazi, M-A-N-E-C-K, Manek Ghazi. It listed out around 15-16 odd principles. You need not write it, but just mention the case law. Alright. So principles were that the court should be very careful, this power should be used sparingly, the court should exercise judicial caution, the standard principles that they usually give out in each judgment. Alright, now attachment before judgment not to affect rights of stranger nor bar decree holder from applying for sale. Attachment before judgment shall not affect the rights existing prior to the attachment of persons not party to the suit. मान लेते हैं पहले से किसी प्रॉपर्टी का एटीएस आपने साइन वाइन कर रखा है, तो उसको नहीं, उसके ऊपर कोई रोक नहीं है. नॉट बार एनी पर्सन होल्डिंग अ डिक्री अगेंस्ट द डिफेंडेंट फ्रॉम अप्लाइंग फॉर द सेल ऑफ द प्रॉपर्टी अंडर अटैचमेंट इन एग्जीक्यूशन ऑफ सच डिक्री. प्रॉपर्टी attached before judgment not to be reattached in execution of decree. तो बेसिकली नेट नेट ऑब्जेक्टिव क्या है इसका? नेट नेट ऑब्जेक्टिव इसका ये है कि भैया कहीं अपनी प्रॉपर्टी कहीं बेच ना देना तुम. सो अटैच हमने पहले कर दिए ताकि कल को अगर तुम्हारे पास सामान ना निकले हम प्रॉपर्टी बेच के पैसा निकलवा लेंगे. Where property is under attachment by virtue of the provision of this order, decree subsequently passed in favor of the plaintiff, it shall not be necessary upon an application for execution of such decree to apply for reattachment of the property. It is already attached. This is important for the purposes of our exam. All right. And yeah, that's about it. This exemption is very important. It says agricultural produce not attachable before judgment. Nothing in this order shall be deemed to authorize the plaintiff to apply for the attachment of any agricultural produce in possession of an agriculturalist. So that cannot be attached. So which of the following cannot be attached before judgment? Agricultural produce. There is no way that you don't end up clearing pre. There is absolutely no way. Order 39, temporary injunction interlocutory orders. अगले लेक्चर में हमने काम करना है. Alright. Now order 38 के साथ हमेशा जाएगा section 95. अभी हमारा वाला ये वाला लेक्चर खत्म नहीं हुआ. Compensation for obtaining arrest, attachment of injunction on insufficient grounds. So 95 will always go alongside order 38. So order 38 has to be read with section 95, wherein any suit in which an arrest or attachment has been effected or a temporary injunction granted under the last preceding section, so it's referring to 94, it appears to the court that such arrest, attachment or injunction was applied on insufficient grounds, मतलब घोर अन्याय हो गया है. The suit of the plaintiff fails, or it appears to the court that there was no reasonable or probable grounds for instituting the same. The defendant may apply to the court and the court may, upon such application, award against the plaintiff by its order such amount not exceeding 50,000 rupees as it deems a reasonable compensation to the defendant for the expense or injury, including injury to reputation caused to him, provided that a court shall not award under the section amount exceeding the limits of its pecuniary jurisdiction. This of course is understandable. This is the question that I wanted to show you. So what is the maximum prescribed limit in case order या order of attachment आ जाता है, या आपके arrest before judgment या attachment before judgment, or any such injunction also, this, या फिर plaintiff केस कल को हार गया लेकिन डिफेंडेंट का तो बहुत खर्चा हो गया, डिफेंडेंट की बेइज्जती हो गई, डिफेंडेंट का राइट रोक दिया गया था प्रॉपर्टी उसके अटैच करके. सो ही मे बी, सो डिफेंडेंट कैन अप्लाई, but that amount cannot exceed 50,000 rupees. I believe this should, in today's time and age, should be on a pro rata basis on the value of the property that is in dispute. Alright, क्योंकि 50,000 रुपये आजकल लोग इतने तो आईफोन ही नहीं आता, फोन ही नहीं आता आजकल. So 94, it was referring to a preceding section, that is 94, in order to prevent the ends of justice from being defeated. So this is the core of all of these provisions. As to दोनों को हमने defendant plaintiff को control में रख के चल रहा है. 95 is talking about compensation for obtaining arrest, as we have already discussed. Alright. Order 39. Do me a favor and just breeze through the order, and I'll discuss this in the next lecture. I have to dictate pointers to you about the theory portion, so that let us say Uttar Pradesh or Uttarakhand or whatever exam that you're taking for, अगर उसके अंदर even in general legal knowledge DJS के अंदर standard अगर question आ गया to elucidate the point of temporary injunctions, so that we are ready with that. So this order 39 will do now in the next lecture, otherwise this will become way too long, and I know what happens with way too long lectures, you don't end up watching them. You're like, अच्छा कल करेंगे, परसों करेंगे, अरे वो बहुत लंबी duration है. So in an online coaching program, the benefit is that I'm talking cut to cut, point to point. This cannot get any shorter than this, because if you were to take this same thing in an offline class with me, herein बीच में इतनी बातचीत करके, एग्जाम्पल करके, डाउट्स इन द सेंस कि सामने वाला स्टूडेंट भी अलग अलग हाइपोथेटिकल सिनारियो बताते रहता है और इसमें पूछता है कि इसमें क्या होगा. बट इन लॉ कोई क्या बता सकता है कि किसी चीज़ में क्या होगा, एक्सेप्ट फॉर द ब्रॉड आउटलाइन ऑफ द केस, ज़्यादातर नहीं बता सकते. दैट इज़ वाई वी कन्फाइन दीज डिस्कशंस टू the absolute crucial things, the sine qua non that you need to clear your exam. All right. Therefore, for people who can manage online in the pre-recorded format, I always say that it is better to do it via this medium. Thanks to God's grace that this technology now exists. All right. Now इस लेक्चर से भी ज़्यादा इंपॉर्टेंट वाला लेक्चर है अगला वाला, वेयर इन 90% टाइम द क्वेश्चन विल पॉप अप फ्रॉम देयर. But ये वाले सारे concepts, and hopefully you've understood it, so that if a fictional situation, a case-based situation arises, let us say in DGS का paper, Haryana का paper, where they more often than not arise, you need to know these provisions, and specifically tomorrow in your career as a judge also, you need to know these provisions. All right, now I see you in the next lecture. Take very good care of yourself.